Good morning, good afternoon, and good evening to all of you joining us today for this second session of the FIFA Football Law Talks. Once a month and until June, we're inviting experts from specific legal fields to talk specially tailored for you on these occasions. To interact with our speakers, please use the Q&A functionality of the Zoom application to send in your questions during the presentation. Once the presentation is over, the questions will be answered by our speakers. Today's talk is about Article 17 of the FIFA Regulation on the Status and Transfer of Players, a fascinating and interesting topic. Who better than the two men deciding upon hundreds of disputes in relation to this article to talk about the understanding of Article 17 of the FIFA RSTP. It is my pleasure to present to you our two speakers, the Deputy Chairman of the FIFA DRC, Clifford Hendel, and Omar Ongaro. Omar, Cliff, good afternoon. And thank you very much for spending this Friday afternoon with us. It's a great pleasure to have you here and to welcome you from Zurich. Please, Clifford, tell us more about this Article 17. The floor is all yours. Thank you.
Thank you, Maya. Yes, it is true, as you mentioned, that both of today's presenters are the two deputy chairs of the DRC. But it is also true that one of us is probably the world's leading expert on the topic to be addressed in this session, having unequaled experience and perspective in the area. And it's not me. What we have agreed is that I will leave essentially all of the substance of the topic today to Omar. For my part, I will provide only a very brief historical overview of the topic on the theory that a page of history is often worth a volume of logic, and then I will step aside. Article 17, consequences of terminating a contract without just cause, is included in Chapter 4 of the RSTP, dealing with the maintenance of contractual stability between professionals and clubs. Obviously, this chapter and this article constitute one of the very pillars of the regulations, as well perhaps as being one of their most conflictive and tricky parts too. As with many other principles embodied in the regulations, the content of Article 17 derives in large part from the agreement between FIFA and UEFA on the one hand, and the European Commission on the other, back in 2001, putting an end to a complaint alleging violation of EU competition law that had been filed by the players' union, FIFPro, against an earlier version of the RSTP. So to a significant extent, Article 17 is and should be understood to be a product of a compromise, a negotiation between differing, even conflicting visions and interests. It is a structure which enshrines or balances substantial elements of, on the one hand, contractual stability, something near and dear to the hearts of clubs and federations, and on the other, the ability to terminate contracts, something near and dear to the hearts of players and their advisors. Needless to say, this is a difficult equilibrium or a difficult balance to strike and to maintain over time as business market practices develop and change. So Article 17 has undergone over the past 2 decades continued but generally incremental evolution. And of course, it's not finished. This evolution has involved periodic amendments to the text of the regulations and a fairly steady flow of jurisprudence emanating both from the DRC and from the CAS as the Supreme Court of sports law. While it is impossible to mention all of these developments, even in the full 1-hour session today, and certainly in my very brief introductory remarks, I did want to mention a few of the key milestones, leaving it to Omar to develop as he sees fit these matters in his presentation that will follow immediately. What are some of the leading cases, CAS cases, over these past 2 decades? Well, back in 2003, the case of Ortega and Fenerbahce was perhaps the first involving important compensation having to be paid by a player to his former club, and also addressing matters such as what constitutes just cause for purposes of Article 17, and when and how sporting sanctions can be imposed on the player. 2005, similar issues were raised in the Mexes Auxerre case, but also the case involved AS Roma, who was brought in as the new club. And the case involved, among other things, consequences, liabilities of a new club, and the explicit extension of FIFA jurisdiction to cases involving maintenance of contractual stability, where an ITC, an international transfer certificate, is being requested, even if the underlying dispute, the underlying employment dispute, is purely national in nature, as it was in this case, between a club and a player of the same nationality. The same case also concluded that the protected period resumes or restarts when a contract is renewed and its duration is extended, and also determined that sporting sanctions on clubs consisted of bans from registering new players for a period of 2 entire consecutive registration periods. These points established in this case were ultimately embodied within the corpus of the RSTP itself. Just to mention 2 other leading cases, landmark cases, Webster and Matusalem, both from 2008. No, I think Matusalem was 2009, but 2008, 2009. These are leading cases in a series of decisions, very fact-driven, complex, sometimes hard to reconcile between one and another, but dealing with the calculation of the amount due from a player to his former club in case of breach of contract by the player after the protected period. Amendments. Yes, the regulations, as most participants today know, are amended rather regularly, and Article 17 is no exception. The most recent important amendments, I think, were those from June of 2018. And the principal changes there were to include Article 14 bis, specific rules permitting a player to terminate a contract for just cause arising from overdue payables, overdue salaries. Also, a specification on how to calculate compensation due to a player in the case of breach by the club, in particular, dealing with the question of mitigated compensation, reducing or offsetting from the residual value of the terminated contract the value of the player's new contract, if he has one. And thirdly, the introduction of the possibility of additional compensation, a kind of penalty in the amount of 3 months' salary, extendable to up to 6 months in egregious circumstances, where a player terminates on the basis of overdue payables. Now that in a thumbnail is my half page of history on this very dense topic. The takeaway, I think, is twofold, and it's what I mentioned a few minutes ago. First, at its core, Article 17 reflects or aims to reflect an equilibrium between conflicting tensions, contractual stability on the one hand, freedom to terminate contracts on the other. And second, that this equilibrium is probably always destined to be unstable, delicate, and always evolving. An interesting area for lawyers indeed. Omar, the floor is yours.
Thank you very much, Cliff, in particular also for your 2 generous words in my regards. And without further ado, I immediately enter into the substance and would like to start with the fact that Article 17 is based on the principle of reciprocity. This means that irrespective of the fact whether it's the player or the club that is having a certain behavior or better misbehavior, mutatis mutandis, the consequences are the same. And they are always involving the payment of compensation and possibly the imposition of sporting sanctions. At this stage, I think it's also important to emphasize that there is neither an obligation for the player nor a right for a club to ask the return of the player to a former club once there is a termination of the contract. The only consequences at that stage are, as I said, payment of compensation and maybe sporting sanctions. This is what we are going to see, and this is what CAS has also confirmed on various occasions. You will see on many slides appearing the CAS logo with reference to certain decisions. Obviously, for reasons of time, I will not be able to enter into the details of all of these decisions, but they serve for you to have a reference about more details of what I'm going to explain. Now, what is the scope of Article 17? Well, if we read the title, it's about terminating a contract without just cause. But now the question is this an exclusive application? And the answer to this is definitely no. As the established jurisprudence has shown, Article 17 is also applied whenever there is a serious breach of contractual obligations by one party, which confers the other party the possibility to terminate the contract with just cause. And the most illustrative example, obviously, is the case where a player terminates a contract for reasons of overdue payables. So it's the player who has a just cause to terminate the contract, and to then Article 17 is applied and the respective consequences. Now, again, this is also reflected in the language actually of Article 17, because if you read there, it's not the party that is terminating the contract that needs to pay compensation, but it's the party that is in breach of the contract. The same is to be found in paragraph 3 and paragraph 4 of Article 17 when it's about sporting sanctions. Again, the article is not speaking about the party terminating the contract, but it's about the party that has breached the contract. So this is important to bear in mind. If we look at Article 17, and I know the just cause is not the topic of the presentation, but you can't understand Article 17 without having an idea of what is a just cause. So there is two articles which refer to this in the regulation. It's Article 14 and the one mentioned by Cliff, a newer one, Article 14b, with a very specific reference to a just cause. In principle, however, there is no definition in the regulations of what is a just cause. Jurisprudence has established a clear guideline in this respect, which is, well, first of all, it needs to be a breach of a certain severity. And then if we clarify what a certain severity means, it is that from an objective third-party point of view, looking at the relation between the two parties, it cannot be expected from one party suffering from the violation of the contractual obligations by the other party, that it continues to fulfill its part of the contract, such as, for example, a serious breach of confidence. In addition to this part of the definition that we have, it is also mentioned now, and an established principle, that the party prior to deciding to terminate the contract, it should do everything possible to find another solution. So the termination of the contract should always be the ultima ratio measure that a party is taking. Again, these are principles which CAS has confirmed on many occasions, including very recent decisions, as you can see on the screen. Now let's have a look very briefly at cases of just cause. Poor performance. Established jurisprudence has clearly indicated that poor performance can never be a reason for a club to terminate a contract with just cause. Another issue, injuries or illness. Again, clear position of CAS and the DRC cannot be considered a just cause for a club to terminate a contract. Overdue payables, on the other side, very clearly a just cause for a player to terminate a contract, with specification in Article 14b about overdue salaries. What about abusive conduct? Again, here we have now a new provision, Article 14, paragraph 2, which in principle says you have a just cause. However, this might be quite a burden for the player to prove that there was actually an abusive conduct. The registration or lack of registration, so a situation where the player is not able to perform his competitive activity at all. Again, clear, this is considered for the player a just cause to terminate the contract by existing jurisprudence. Then we have two areas which are a bit less clear. We have the medical negligence. In principle, if a player suffers medical negligence from his club, this could be a just cause to terminate the contract. However, again, the burden lies on the player to prove it. And for example, in a case which I will address later on, in Appia, it was denied because the player was not able to prove that there was indeed a medical negligence. And the last example I would like to mention are absence of visa and work permits. Here it depends on who is trying to invoke it. If the player is saying, I have a just cause to terminate the contract because the club did not provide me with the necessary work permit of the visa, then the answer normally is yes, the player has a just cause to terminate the contract. As a flip side, obviously, the club cannot use the absence of a visa or a work permit to put an end to the contract for just cause. So you see, these are all examples, but again, there is no general definition. I already spoke very briefly about the two specifications. We have the abusive conduct and the terminating a contract with just cause for outstanding salaries, both introduced in June 2018. These two are a kind of specification of just causes which fit into the general rule that there is no definition, but now for two very specific aspects, at least the regulations provide for clearer specifications that enhance legal security. Now, let's go to the consequences that I mentioned before, the payment of compensation. So we have a termination of a contract without just cause, and in all cases, we would have payment of compensation. In all cases, well, yes, normally it is all cases, but we have some exceptions. A recent one from CAS, some others that I've mentioned here. And in all these cases, the problem is that the club was not able, finally, to prove that it suffered any harm. So normally these cases concern situations where it is the player that should pay compensation to a club, and the club is not able to prove that it suffered a real harm. We have also cases where there is a reciprocal responsibility for the termination. So at times here as well, there is no compensation awarded, or where there is a shared damage between the two parties, which in the end can be kind of compensated one with the other, and therefore also there is no entitlement to compensation. But again, these are very few exceptions, and normally compensation is awarded in all cases. So compensation, if we have a compensation, we need to calculate it. And here comes one of the points raised also already by. There is a relatively wide margin of discretion for the deciding authorities when having to establish the compensation. And this is in particular the case for cases where it's the player who has to pay compensation to the club. As we will see later on, the case where the club has to pay is a lot more precise in the regulations, in particular since June 2018. This wide margin of discretion is repeatedly emphasized by CAS. They say it should be a compensation that adequately compensates the damage and should not go beyond the effective harm. That's why sometimes no compensation is awarded, as I just said. And the principle, again, is reciprocal. It doesn't matter who is breaching the contract, the other party will be entitled to compensation. What is the first step that the regulations provide? Article 17, first of all, says that the parties can include in their contract a clause which establishes the amount of compensation due in case of breach of contract. These are the so-called liquidated damages clause. It is important to emphasize that these clauses need to be proportional. If the clause is not proportionate, then it should be reduced to a reasonable amount. Important to note, just because a clause, a liquidated damages clause is not proportionate, it should not be declared invalid, but it should be reduced to a reasonable amount. This is an important aspect which CAS has repeatedly emphasized, and where the DRC sometimes is going in a different direction, just disregarding the clause. But if the clause is there, it should not actually be disregarded. If it's disproportionate, it should be reduced to a proportionate amount. This is what CAS has said on various occasions. The second aspect is the principle of reciprocity. Now, this is less obvious. The DRC tends to request it. So they say if you have a liquidated damages clause, it should be reciprocal for the club and for the player. CAS is less consistent. We have a series of awards where they ask, like the DRC, for this kind of clauses to be reciprocal, while we have another series of decisions of CAS where they deem that this is not necessary because under Swiss law, this is not a requirement. So here there is a certain legal uncertainty about whether or not they need to be reciprocal. I think that there is a nice CAS award which centers the question better. It's not about the reciprocity, it's really more about the proportionality and the balance. If we have liquidated damages clauses, it should be in a way that both sides, club and the player, will be touched by these kind of clauses in a similar manner and in a similar way, and not that the club or the player are suffering more than the other one. So, for example, it should not be that the club will always be entitled to a compensation from the player equivalent to the entire duration of the contract, for example, or even more, while the player in the end will only receive a couple of weeks or months of compensation. So CAS has also tried to address this, probably recognizing that there was a certain inconsistency, and you can find more details again in these various awards that I just mentioned. A small excursus on buyout clauses. This is not a liquidated damages clause, and this is not about compensation for breach of contract. These are clauses which grant a party the right to terminate a contract. So normally it's the player. Against full and unconditional payment of a certain amount, the contract can be terminated at any given time. And this is a clause granting a right. So it's not about establishing in advance an amount due for compensation for breach of contract. No, it's about paying for the right to be able to terminate the contract. And because it's a right, obviously, we will not have a breach of contract, and consequently, we will also not have any sporting sanctions. Now, if we don't have a contractual agreement, what should then apply? Here we have the two constellations. We have compensation due to a club and other rules for compensation due to a player. The rules for compensation due to a player are relatively new since June 2018, and as you will see, and as already mentioned, they have limited the discretion of the deciding authority. Let's first look at the side of compensation due to a club. So here the regulations tell us if there is no contractual provision as a liquidated damages clause, the deciding authority has to look at the law of the country concerned, specificity of sport, and other objective criteria. In the case of the player, as said, there is this lex specialis that we will analyze later on. Let's start first with the club. So what is the law of the country concerned? Well, first important information. Article 17 says, deciding authority take into consideration national law, not do apply national law. This is important. Margin of discretion. What happens in practice? Well, you can scan through all the decisions which are published on FIFA.com or legalfifa.com from the DRC, and you will hardly ever find a substantial reference to national law. What the DRC normally applies are the regulations, the RSTP, other regulations of FIFA, the statutes, general principle of law, contractual law, and if no solution can be found in all of these aspects, maybe Swiss law can also be applied to fill the gaps. But again, national law is hardly ever touched. A bit slightly different at cost level, as we will see. Why this? Well, there is a desire for equal treatment in the perspective of where the breach occurs, between which nationalities the breach occurs. It should be a clear and traceable jurisprudence, easy to understand, and legal security and certainty should be the main aims of the application of the rules. And therefore, obviously, it's an obstacle to all of this principle if every single dispute would be treated differently in accordance with potential national law. The legitimacy and the aim of this approach has been confirmed by CAS in various occasions. The first one was Bueno Barotti several years ago, or 15 years ago, when the primacy of this principle was confirmed. And CAS also emphasizes the intention to create a basis for as much harmonization as possible. And they have basically the same approach in the CAS code. If you look at the two articles of reference, one for the ordinary proceeding, one for the appeal proceeding, they also tend to try to apply the regulations of the association with priority. So what is CAS actually doing? CAS is normally applying Article 17 plus Swiss law if there is a gap. Now, I found an interesting CAS award, quite a recent one, where I think you find a very accurate and nice summary of how national law should be looked at. If the matter at stake is addressed by Article 17, then you should apply Article 17 and its principles. If it's not complete, then you should apply Swiss law to close the gap. If the regulations do not provide for an answer to the specific question, then and only then you should look if the parties had a choice of law. If there was a choice of law, then this law should be applied. If there wasn't, then Swiss law should again be applied to address this specific matter. I think this is, in summary, what should really happen, and this is what CAS is actually doing. Again, at DRC level, we are definitely having a more straightforward approach, which is to just go for regulations and general principles combined by maybe Swiss law. Specificity of sport, also, it has to be considered, not applied. And what is important, it is only to adapt a final calculation. So you first calculate according to all the principles, and only if you feel that somehow it does not really seem to fit, then you should use the the specificity of sport to adjust the result that has been found. It should, however, not just undermine the principles of Article 17 and use the specificity of sport just randomly to add or deduct something from the compensation, but it should only be a last point that is mentioned. This has also been clearly emphasized by CAS. It is to adjust the results because they somehow seem to be not in line with what is this special world of sport in the world of CAS. So it's an element to adjust a result based on the other elements of calculation and not a single element for the calculation itself. How is it applied? Well, if you go through the jurisprudence of the DRC, you will see that the DRC has a certain reluctance in applying specificity of sport. So they normally, we do not really add or deduct anything from the compensation calculated on the basis of the other principles. Whereas CAS has at times used it, again, just to adjust specific results. And CAS does this in both directions. Sometimes it reduces compensation due, for example, in the case of a player who had to pay a certain compensation, and because his new salary was relatively moderate, they thought that the compensation calculated on the basis of the general principles was too high, so they reduced it a bit. We have also the other way around, where more compensation was awarded to a player because the club had an unethical behavior. So in summary, we could say that an adjustment can take place if we have an extraordinary mean behavior of one of the party at fault. The timing of the termination can obviously have an impact. If a club is terminating a contract 2 days after the closure of the registration period, or the player is doing the same, this may have a particularly important impact if we feel that this was done on purpose. What was the role of the player in the SCOT? Was he the captain of the team, this may have an impact, or the commitment of the player to the club previously. So had this been a player who played many, many years for the same club, had his contract even been extended several times, and then only then there was a disruption, this may lead the deciding authority to adjust the amount of compensation due based on the criteria of the specificity of sport. Third element mentioned by Article 17, the objective criteria. I think this is not a surprise. The list of criteria, so the remuneration under the new and the old contract, the duration of the contract, fees and expenses paid at the time of acquiring services, and whether the breach occurred during the protected period, these are examples. This is not an exhaustive list. I think this is known to everybody by now. Now, what is the calculation in practice? Well, in practice, we have to distinguish between the DRC and the CAS approach. Remember, we are still on the side of compensation due to a club. So the DRC, well, fundamentally, what all deciding bodies try to establish is the value to be attributed to the services of the player, because this is the damage caused to the club. The club is losing the services of the player, so we have to find the value attributed to this. And the DRC starts this exercise by looking at the value of the contract that was terminated. Why? Because it says, well, that's the value attributed to the services of the player by the club who is now suffering from the termination of the contract. Then the DRC looked at the value of the new contract for the same period of time. Why? Well, because this is somehow reflecting the value attributed to the services of the player at the moment very close to the contractual breach. And the average of these two amounts is, in the eyes of the DRC, a very good indicator for what I said at the beginning, the value attributed to the services of the player. In addition to this, they add potentially the non-amortized transfer compensation or agent's fee that are persisting. And as you can see, what the DRC is normally looking at are criteria 1, 2, 3, and 4 in Article 17. The fact if it's inside the protected period or not is actually not really taken up by the DRC anymore. And what is nice to see is that CAS, at least in some decision, has considered this at least not to be unreasonable. And we have decisions where CAS has one-to-one confirmed the calculation on this basis made by the DRC. So what is, on the other hand, CAS doing? Well, it's a bit more complicated. And here I come obviously to what Cliff has mentioned, to the nice Webster versus Methusalem situation. These were the two opening cases of these decisions about calculating compensation due to a club. At the basis of all of these decisions, please bear in mind the wide margin of discretion, which is always over and over and repeatedly emphasized by CAS in many, many decisions. So what was the first decision, Webster? Well, the panel said, well, first, is the estimated transfer value something that could be taken into account? And they said, no, sorry, it's not objective. We cannot take it into account. What about the remuneration under the new contract, which is also mentioned in Article 17? Well, the panel was of the opinion that it would be punitive towards the player to look at that contract, which is a new one, it's not the one being breached, and therefore they also did not deem it appropriate to take it into account. What, however, they deemed appropriate as the only one element, they said it's the residual value of the contract that was terminated, because it's the same when it's the club that terminates the contract without just cause. So the only criteria that this panel took into account was the remaining value of the contract that was early terminated. This Webster approach, which has not gained the upper hand, was, however, at least confirmed one occasion later in 2017. The upper hand was the decision of Matusalem. This is today probably the leading direction that chosen by CAS. And here, the introduction of the so-called positive interest, basically calculation of the compensation should lead to a situation where the injured party is put back in a position as if the contract had never been breached. So in Matusalem was established that first, the estimated transfer value can be an element for determining a damage because it's a reality of the world of football and because it's an economic value which is worth protection. Then, CAS also said that the residual value of the contract that was terminated should be taken into account, but contrary to the DRC and contrary to Webster, what they said is actually this is money saved by the former club. So this is actually mitigating the damages. So we should take this into account, but we should deduct it from the compensation due. Then the value of the new contract, they said absolutely. This is reflecting the value attributed to the services of the player, and as the DRC, the non-amortized amount. These are the basic principles where the majority of the cases decided by CAS are actually being based on. Now, what was the continuation? Very briefly, after Matusalem, we had a confirmation of the positive interest approach for the first time in El Hadari, for example. Here, the estimated value of the transfer was put in the foreground. Why? Because the new club had actually made an offer to the former club already, how much they would be ready to pay. And so the panel deemed that this was a clear indication about the value attributed to the service of the player, and consequently, compensation was mainly based on that amount. Then we had the case of Appia, which I already mentioned, where no compensation was awarded. The positive interest principle was confirmed, so referring to Matusalem. However, here they said, well, there was no real damage for the club, mainly for one reason. The player was seriously injured at the time the contract was terminated. So the club would in any case not have been able to use his services, but they should have paid his salaries anyway. So in the end, there was no real harm and no real damage, and so there was no compensation awarded. Another example is the one of Tony Silva, another goalkeeper. Extraordinary. When I was preparing this, I saw that many decisions concern actually goalkeepers. Tony Silva, here, similar to El Hadari, there had already been a kind of a draft transfer agreement with a draft transfer fee included, and the panel based, therefore, the estimated damage of the transfer on the transfer value that was included in the transfer agreement. Another one, which is important because it introduced the notion of the replacement costs. So a new element, although in this De Sanctis decision, the panel said we are not deviating from Matusalem, but what we are doing is there might be another way to establish the value of the services of the player by means of the replacement costs. And this is what's done in this case, where they took the costs to engage two, not even one goalkeeper, replacing De Sanctis, and including this. Here, in addition, they confirmed, like in Matusalem, the saved salaries to be deducted, and here the specificity of sport was also addressed, I think mainly because De Sanctis had been a player of Udinese for many, many years with several extensions of the club. So again, the replacement costs, first time in De Sanctis, there is another more recent award where again replacement costs were taken into account to establish the value of the damage caused. As a final remark regarding this calculation process, we have the joint liability of the new club. It's always the new club with which the player is first registered. It's an automatic liability of the new club, so irrespective of fault, guilt, or negligence. And it's always for these reasons. It's an additional guarantee for the payment. It contributes to the contractual stability, obviously, and it relieves financial burden of the player. This was the main reason why it was introduced. And it avoids an unjustified enrichment of the new club, which would be able to engage a new player without having to pay any compensation if only the player would have. Now, this is the rule which has been confirmed by counsels on many occasions, but there are exceptions. The most famous one is probably the one of Mutu. And the starting point here is that it's not the player who terminates a contract without just cause, it's the club terminating with just cause. And here the panel says, well, we confirm all the objectives, as I mentioned before. However, if it's the club that terminates the contract, the player has no option then to look for a new club. And therefore, it's not appropriate to apply a joint liability because we would not reach the pursued objectives. So basically what the cost says is if it's the club that terminates the contract and the player had actually no reason to leave, then the joint liability should not apply. A second important case in this case is Diarra. We have only a DRC decision, and the DRC decision basically said at the moment of the decision, there was no new club, so no joint liability possible. But the important thing is in an obiter dictum in the decision, the DRC also says, well, we need legal certainty. So today there is no new club, no joint liability, but there shall also be no joint liability in the future. We don't know what COS would say about this because there was an appeal, but the parties settled in front of COS. A last one, Abdulaziz, less famous player, a quite complicated case. I'm just putting it here, but for time reasons, I'm not entering into the details. The DRC said, yes, there should be joint liability. The panel at COS confirmed that that the automatic application as a rule, but they also said that it may be that under truly exceptional circumstances, Article 17, paragraph 2 should not apply. And these truly exceptional circumstances may be the case if none of the reasons that I mentioned before for the existence of Article 17.2 are met. And analyzing them, they came to the conclusion that in this very specific case, none of these objective criteria or reasons to be were met, and therefore the joint liability was also denied. Now, let's go to the player side. A lot simpler since June 18, because we have a quite clear indication how the competent authorities needs to decide. Increased legal security, reduced margin of discretion. The majority of the elements are a confirmation of the jurisprudence with an important novelty, which is the additional compensation. So the starting point, there are two different situations to be distinguished. First one is the player has found a new employment after the termination or he did not. The decisive moment to establish this is the time when the decision is taken. And here, obviously, we may have a difference between the decision of the DRC and the decision of COS, because we may have a decision of the DRC where the player is still without a new contract, while for the time there is an appeal, he has found a new contract. So COS may come to a different decision just because in the meantime, the basic situation has changed. So what is the starting point? In both cases, it's a positive interest. The player should be put in the same position as if the contract had been duly performed. So if we look at the player that did not find a new employment, compensation is based on the residual value of that's what he gets as compensation. If we look at the player that has found a new employment, we have as well the starting point, the residual value, but we deduct what he earns somewhere, so the new contract, because this is mitigating his damage. And this is confirmation of the long-standing practice of the DRC. As I said, for the situation of no new employment contract, this is it. If the player found a new employment contract, we have the novelty. If the termination was due to overdue payables and only due to overdue payables, so if the termination is for any other reason, forget that additional point. But if this was the case, the deciding authority has automatically to apply 3 additional months of compensation. There's an upper limit. We cannot go beyond the residual value of the contract. But this is an additional compensation awarded to the player. In case of egregious circumstances, there is a margin of discretion for an additional 1, 2, or 3 monthly salaries given to the deciding authority. This is done on a case-by-case basis, and so far the DRC has applied more of this compensation in cases where, besides the overdue payables, player was, for example, forced to train alone, deprived of his passport, promised the registration but he was never registered, shortened the holidays, forced to vacate the apartment. So additional elements, and then there is this thing. So we have 3 automatic one. We have the possibility to increase up to 6, but never higher than the residual value. I'm trying to run now because of reasons of time. A particularity here, when it's about the player having to pay compensation, this is the basic, but if at national level there is a collective bargaining agreement validly negotiated between player and club representatives, the conditions of the CBA shall prevail. This is a clear efflux of the fact that this provision was drafted after consulting in depth with the stakeholders, and the CBA obviously is the main source for stakeholders, so they want the prevalence of these documents. Sporting sanctions, they are in addition to pay compensation, and they only apply if the breach occurred during the first part of it, during the so-called protected period. And the protected period is, now that the definition of season has changed, a period of 3 years. So the first 3 years of a contract fall under the protected period. If there is a termination without just cause during that protected period, in addition to paying compensation, there will be sporting sanction, either on the player or the club, depending on who is at fault. Now, what's the nature? The wording seems to indicate, the wording of Article 17, that it's an obligation for the deciding authority to impose them. However, jurisprudence, established jurisprudence of the DRC, no, we have a margin of discretion, so it's just an authorization. We can, but we don't have to. COS has confirmed that this approach is okay. COS has said that the application of sporting sanctions need justified by specific circumstances. COS has said that a case-by-case or a flexible approach is absolutely fine. COS has said that the repeat offense, for example, is one of these specific circumstances that justifies the imposition of sporting sanctions. And the DRC has said that the repeat offender is somebody that breaches the contract more than 4 times in the last 2 years preceding the decision. Now, this margin of discretion only concerns the possibility, yes or no, to sporting sanctions, but not to the level of the sporting sanction. The sporting sanction is a 4-month restriction on playing in official matches for a player when it's decided that sporting sanctions will be there. It's not possible to give 3 or 2 months. There is no discretion in this respect. On the club, it's a ban on registering any new players, and that's it. It's either yes or no, but you cannot go below these 2 points. Last 2 slides. Inducement, the new club active stance inducing the player to breach contract cannot be accepted. Sporting sanctions, the same as for the one that the club is breaching contract. To emphasize and reinforce this, there is a regulatory assumption. The burden of proof is reversed. It's for the new club to prove that they did not induce, and not for the former club to prove that there was an inducement. The presumption obviously can be rebutted, and there is an interesting award of COS in this respect, which clearly says obviously what happens after the breach and not taking into consideration. Last slide. Inducement to breach of contract is accessory to the actual breach. This means that only a breach that occurs during the protected period can also lead to sanctions for inducement. And second, you can not only lodge a claim for inducement, you have to lodge a claim against the player for breach, and then in addition for the inducement, but an isolated claim for inducement would not be accepted. That's it. Thank you very much for your attention, and I'm open to questions, obviously. Thank you.
Thank you very much to both of you, to Cliff and to Omar, for this very detailed presentation. We have more than 370 participants watching here today, and we have many questions, so I'm already starting. We have the first question for you, Cliff. You can see it on your main screen. So please while I'm still speaking, you have time to read it, and then in a few seconds you can start to answer the question for one of our nice participants that seems to know a few details more than maybe some others. So whenever you're ready, Cliff, please.
Yes, indeed. I think it's unfortunate that this format doesn't allow the participant who has very clear ideas, in particular, of how damages are calculated in other sectors, in other areas. Yes, I don't deny that I am a former aviation finance counsel. Whether the system treats players as chattel or not, chattel meaning things, cosas. I'm not sure. I'm not sure. I think this issue is it is indeed very complex. As Omar mentioned, the guidelines that are set out or included in the rules are guidelines to be taken into consideration. They're not exhaustive. They do change from time to time, and they change consistent and in accordance with practice and market expectations. So I'm not fully able to answer or debate the topic, but I would resist a little bit the suggestion that that the rules reflect a treatment of players as chattel, in the sense that their value is being attributed in an artificial or a restrictive way, more so than might be appropriate and more so than might be in other contexts. But I think beyond that, this is perhaps a topic to be that could be discussed further and better offline.
Thank you very much. Here we have the next one. It's coming from a Spanish-speaking colleague. It's in connection with if it's a just cause, if a player is sent to be playing alone or to the reserve team. So here it's up to both of you, whoever would like to answer this question.
Well, maybe since Cliff just had one, I take the second one. If you don't mind, Cliff, obviously.
Not at all.
Well, I mean, this is one of the cases which we would have to address, as I said, on a case-by-case basis. And Article 14, Paragraph 2, the new one of June 18, may be of assistance. And the question is always, we have to put this in relation to what we have set as a definition of a just cause, and if this is an abusive conduct forcing a party into a certain direction. And it's also depending a bit on the value, on the contents of the contractual clauses. I just saw in a recent dispute a contract where the contract was explicitly mentioning that this was not a contract exclusive for the first team of a club. So this may play a role. There's certainly a right for the player to participate and to be able to train at the standards that he deserves. So you cannot deprive him of this possibility. But obviously only 11 can play. So the question then is, where does he need to train? Training alone, there is jurisprudence, per se does not mean necessarily that this is not feasible or appropriate, but there should be clear indications. There should be training alone to recover from an injury, for example. There should be clear indications for how long this will persist. They should be aware that if he performs, if he does it, he will get the chance to go back. Obviously, the player has to start training in the morning at 6 o'clock in Siberia, with wind and rain, and he is there alone. There is no trainer around. This is different from a player who has an appropriate staff looking after him, and for a period of 2 weeks after an injury is training alone. Or he plays in the reserve team because he had a period of poor performance and the club is trying to bring him back to the level. So again, I'm sorry, there is no black and white answer to this. It depends a bit on the general circumstances.
Thank you very much. Here we have a French question. So you take your time, please, to read it. As usual, it's quite detailed. And since we are 1-1 on the match, I leave it up to you to decide if this French question goes to Cliff or if it will end up with Omar answering the question.
Well, I might take a first jab at the question, and Omar might want to then chime in as well. I'm not aware of this French legislation that prohibits buyout clauses. I live in Spain, where buyout clauses are very, very frequent. So I don't know. I think Omar discussed buyout clauses in his presentation that FIFA DRC currently doesn't prohibit or disregard buyout clauses. So I don't know what the confrontation might be in a circumstance where a jurisdiction, local law might prohibit, and otherwise they are not prohibited by, let's say, the FIFA rules. I would think the local prohibition would not be applied for the same reason that Omar discussed earlier in another context, which is to say, in general, at the DRC, at FIFA, we're going to apply our own rules, and maybe Swiss rules or general principles. But generally, for reasons of efficiency, uniformity, etc., we're not going to look to and apply local law, even on issues as, well, let's say, important as this one. I don't know, Omar, if I have misspoken or if you have a different perspective.
No, absolutely. I would certainly tend to agree. I mean, it's even more in Spain, based on a royal decree. It's mandatory to have buyout clauses, and in France it's prohibited. You're absolutely right. As I said, I mean, national law would not be considered. FIFA is not prohibiting them, and therefore, most likely in an international context, the DRC would recognize the buyout clause included, even if the contract is signed in France and the French CBA is not allowing them and is not even accepting the registration of this contract. Obviously, this does not prevent then the French authorities from sanctioning the parties because they have included and not registered.
And here we have another question. Now we go into the area of calculating compensation and the existence of damage. If the element of the damage is a sine qua non to be able to grant compensation. Gentlemen.
Well, I may start this time and then Cliff may jump in. I think that cost is definitely going in that direction, and I think that the DRC needs to follow in this respect. There is this very recent decision about the Swedish player, which is one that I mentioned, and where no compensation was awarded because the club was not able to demonstrate that they suffered any harm, actually. This is very recent. And I think that indeed, I mean, even if the text says compensation is due in any case, if at the same time we say club should, no, the calculation of the compensation should not lead to more than the damage suffered, then the damage has to be the basis. If there was no damage, there should not be any compensation awarded. And interestingly, maybe before Article 17.1.2, the new one on the calculation of compensation due to a player came into force, we had actually a lot of cases where the player was not awarded any compensation by the simple fact that the new contract had a higher value than the previous one. So the mitigation was higher than the damage. And the DRC regularly said, sorry, we cannot give you any compensation because there was no damage. So if we take it from there, if we take what Cost is saying, again, in the more recent decisions, I have quite a clear opinion. Yes, the damage needs to be demonstrated. Otherwise, you can't get compensation. I don't know, Cliff, if you agree or.
I'm not sure if I agree or disagree, but yes, there is an underlying element of avoiding unjust enrichment, or a decision maker wants to avoid the possibility, the appearance, the suggestion of an unjust enrichment, of an unfair, inappropriate benefit from a termination or an event. And that's why I think the CAS and the DRC, in the circumstance that you mentioned, of mitigation that exceeds the value of the terminated contract, would be reluctant, could be reluctant, perhaps should be reluctant to just automatically, let's say, write a check. But that too, it opens, or it shows how open, how broad the discretion is in these areas, and how hard it sometimes is to predict the outcome of particular cases.
It's specific for Omar, and it's related to the joint liability when a player breaches a contract and the new club is ordered to pay, and then the possibility of the club to claim against the player.
Well, as I said before, this possibility exists. We were never, to the best of my knowledge, confronted with such a case. I would say, I'm not, I mean, I didn't really think about it, but I'm not necessarily sure that the club would need to show that they proceeded with the due diligence. Why? Because the joint liability, as I said, in principle is an automatic consequence. So the club is just signing the player, and then if they have to jump in, they may ask the player to refund this money. And why? Because they might jump in order to avoid disciplinary sanctions against the player, which then again would turn against the club if they cannot use the services of the player. So the player is not paying disciplinary sanctions, and banned from playing in official matches. So the club takes the responsibility, joint liability they pay to avoid that, but under the condition that they would get the money back from the player. Do they also need to include this in the employment contract in advance? Again, not necessarily. I mean, this is in fact the main debtor. The main debtor is the player. The main debtor is the player. It's the player who breached the contract. So on this basis, potentially, I think even if they didn't include a specific clause in the contract, they could do so. But on a practical perspective, this might obviously be quite tricky if you have a new player and the first thing you try to do is to recover the money. So that's possibly why we didn't really face this kind of litigations or situations so far. I don't know if the question is answered more or less sufficiently.
Thank you very much to both of you, Omar and to Cliff, for joining us here. We have much more questions, but I think we need to come to an end. It has been a very interesting presentation, and we really thank you, both of you, for sharing with us this Friday afternoon. Thank you for being with us here. I would also like to, on behalf of FIFA, tell you that it has been a great talk, and whoever was not able to join us today, please be informed that we have all recordings available as of next week on the FIFA webpage. We will have also the recordings in Spanish and in French, so you can rewatch this, or in case you would like to see again something more in detail, you can always have a look at these documents on the Legal FIFA page under the Education tab. So we're coming to an end of this month's talk, and the next talk is scheduled for exactly in a month, on the 26th of March. We will be here again at the same time, 3 o'clock in the afternoon, and we will have with us the CAS arbitrator, Mark Howell, to speak about the financial fair play in football, an overview of the models and the CAS jurisprudence. I hope to see as many as today for the next talk, and I wish you all a very pleasant Friday afternoon, wherever you are, and a nice weekend. Thank you very much, and goodbye.